應該
Members, good morning. We formed a quorum and it's also the appointed time. May I call the meeting to order? The minutes of our meeting held on the 17th of December 2018 have been circulated to members, and the Secretariat has not received any proposal for amendments. So can we confirm the minutes, please? Yes, thank you. Please invite the HKICPA and the administration to join us now. And may I draw members' attention to ROP 83A in relation to declaration of interest. If you have a direct or indirect pecuniary interest in any of the item on the agenda today, please declare the nature of the interest involved before you speak. All right, let us welcome representatives from the HKICPA and the administration. We have received papers from Mr. Kenneth LEUNG, the Institute, as well as the administration in relation to issues raised at the last meeting, and also views expressed by deputations. And please refer to papers CP 1591/1819 and 03. And then we have further views from the Hong Kong Accounting Professionals Association, as well as the Vidy paper CB 1591/1819 and we've also got extracts from the PA ordinance prepared by the Legal Service Division. That is paper CB 1591/1819 I'll give the floor to Mr. Kenneth LEUNG to present his papers before I invite the administration and the institute to respond. Thank you. Please refer to paper CB 1591/1819 for myself. The spirit of the bill is to protect practicing and registered accountants so that they can carry out audit work. And the Institute of Certified Public Accountants has 43,573 members and 19,148 students. It is the largest professional body in Hong Kong. Among the 43,573 members, 4,852 of them hold practicing certificates, and therefore they can perform statutory audit work. 38,700 odd of them are non-practicing members who may be providing other services, including but not limited to financial accounting, management accounting, financial management, corporate services, and taxation. One of the main objectives of the bill is to protect members who are non-practicing members. So to be a member of the Institute, you have to pass the qualifying program by taking examinations, and you have to engage in at least 120 hours of continuing professional development over a 3-year period. And members are required to perform his work in accordance with the professional standards and guidelines issued by the Institute. This is an important assurance of our quality of work to the public. And this is also to ensure that services rendered by our members are very different from those provided by other individuals. We're not like lawyers. Now, for a lawyer, many of the services of a lawyer cannot be provided by a non-lawyer. And for our non-practicing members, they are providing services very similar to other non-members of the Institute. Our bill seeks to protect the rights and ensure the quality of services of our non-practicing members. As regards issues raised at the last meeting, the first is whether the bill will hinder body corporates carrying out businesses such as bookkeeping, taxation, company secretary, or consultancy services. Let me reiterate that they can continue to perform such duties. The bill doesn't prevent anyone from performing such duties. They can continue to render such services. Now, if these individuals use prohibited descriptions or characters under the bill. Now, these characters and descriptions are very clearly stated. We've consulted the Competition Commission and members from the industry when drafting the bill, and we have chosen the prohibited descriptions or characters very carefully to ensure a successful prosecution. Now, if you have used the term inadvertently, then you will not be criminally liable, because we have to prove criminal intention, that you have the intention to mislead the public into believing that you are a practicing member or practice unit under the PAO before you will be convicted. And as for the suggestion by the Association of Chartered Certified Accountants, as I said, the purpose of the bill is to protect the members of the industry performing audit work. We want to ensure that audit work can be given some basic protection. And the third point is about members of any institute of accountants outside Hong Kong. Now, if they have obtained professional qualifications, then under Section 42(2) of the PA Ordinance, they are entitled to continue to use any description or initials that he is entitled to use under his own professional body. And the other point is about collusion between bogus CPA firms and unscrupulous CPAs. The Institute has always taken very stringent enforcement or monitoring actions against such CPAs. And as for views from deputations, now we have addressed the concerns raised by the Association of Chartered Certified Accountants. Now, accounting qualifications obtained outside Hong Kong can continue to be used, and there is no prohibition of bookkeeping, etc. duties performed by other individuals. And we have only got a few prohibited descriptions and characters, and we do not have an all-embracing prohibition of use of terms. I'm going to introduce a CSA to the bill to the commencement of the bill to the 1st of January 2020, so that there will be time for individuals to be prepared And then we can also publicize the new provisions to ensure that people will not be inadvertently caught. Members of the industry are supportive of the bill, and I have also replied to emails from members of the public who use accounting services from time to time, and then a professional body that provide company services also supports the bill. To secure a successful conviction against a company that has used the prohibited terms, the intention has to be proved first. And the administration has provided a very clear legal advice on this point. Thank you. The HKICPA explained his paper to us. Thank you. Mr. Leung has already responded to the views of deputations, and the Institute echoes his views with just as one supplement. Because there is one point that relates to the Institute only, and the Chinese the Society of Chinese Accountants and Auditors would like us to include in our website list called the Scam Alert, similar to that of the Law Society of Hong Kong. This suggestion was in fact considered by the Institute in the past. We have the view that putting these bogus CPA firms on our website might have the negative effect of promoting them. So we have instead decided to enhance the Hong Kong CPA practice directory in our website, and this is to address the point raised by the Society of Chinese Accountants and Auditors. And in Part C of our response, we've provided information on penalties for offences relating to the use of designated or misleading description by individuals, firms, and companies which are non-professional accountants. This is in response to a request by a deputation at the last meeting. So we provided information on some other jurisdictions, and there are criminal sanctions in these jurisdictions. We're asked to conduct further research as regards the penalties. So we have reviewed the law in Canada and the U.S., which are relatively clearer, although they have different stakes, but they have clear accountancy acts, public accountants acts. The maximum fine of few provinces in Canada have been presented. They have different fines for the first and second and third offences, and each province is different, and ranges from 2,000 Canadian dollars to 20,000 Canadian dollars. And we've also got a few stakes from the U.S. Some impose a fine of $1,000, and the highest is 30,000 US dollars. So I think the proposal by Mr. Kenneth Leung is a middle-of-the-road proposal. In some states in the U.S., there is even imprisonment of 6 months to 1 year. And under the PAO, there is also a maximum term of imprisonment for offences under Section 42. The maximum term of imprisonment is 1 year. Some members asked about the prohibited qualifications. Can the bill be shelved because under the current ordinance, prosecutions can be taken already? The Institute has seen terms such as this and that, registered accounting, and they are not members of the institute. Now, under the current ordinance, nothing can be done about them. About 2 years ago, there was a firm.
即係
XX professional accounting, which is not a member of our association nor a practicing unit. It had a lot of advertisements. We believe that would mislead the public that it is a registered practicing unit supervised by the HKICPA. Under the law at present, professional accounting is not a prohibited or registered accounting is not a title prohibited to be used. Now, the company registrar has the power to ask a company to change its name if it is in breach of public interest. But with regard to XX professional accounting, it is not a registered limited company with the company registrar. Now, it has to obtain a business registrar, of course, a business registration, of course, but the power or the commissioner of the IRD does not have the power to ask the company to change its registered name. That is an example. At present, if the law is not changed, then we cannot do anything about it. Is it just the only example, or there are many such examples? This is the one we were aware of, and we had done something about it. In response to the views by some other bodies with regard to substandard financial reports, and also those making referrals. Now, we strictly supervise our auditors, certified accountants, and certified accounting practicing units may have contracted out some of their work to non-registered units, but the member has to done everything required in terms of quality control. Because of the practice review program in our association, each practicing unit is subject to checking. And if we found that there is any breach, the practicing unit has not done anything, done something which is required to do, or if there is any complaint, then we will deal with such matters seriously, and our disciplines committee will take disciplinary action against a practicing unit or member. And we have cancelled their practicing certificate in some cases. That's all we want to add. The administration. Now, since at the last meeting, members raised a concern in respect of the amendment to certain provisions, and there is a description that if someone someone has to use a certain description which may breach the law. There is an intent to cause people to reasonably believe that it is a registered practicing unit under the HKICPA. In response to members' view, we have consulted the view of we have consulted the view of DOJ, and the point is to clarify what is meant by intent and also beyond reasonable doubt. Now, the intention is that if the person or the defendant admits, then that's the simplest way, and if there is no admission, then the prosecutor will have to consider the details of the case to infer whether there is such an intention. the using of the designated description may lead to a consequence in which a certain person is misled into believing that practicing unit is a unit registered with the HKICPA. The consequence, according to the DOJ, is only one point of the evidence, and all other evidence in the case will have to be considered. Say whether other things have been said or described, and whether further information would lead to any misleading. According to the DOJ, the prosecution must establish beyond reasonable doubt the threshold is the same. The prosecution has to prove that making use of such designated descriptions would cause people to believe objectively that this unit is a registered unit with the HKICPA. And only Mr. James Toh is in the line, so let us give him 5 minutes. Chairman, last time I asked a number of questions, and this time the relevant units and bodies and the administration have responded and have provided further information in respect of prosecution, production of evidence. With regard to the view of paper 59105, I find the second paragraph which is very simple, yet I agree. I want to deal with that. Now this is Mr. Leung's bill. Now, what is the situation Mr. Leung wants to deal with, and whether we can agree on which is the place we should strengthen the enforcement. Now, with regard to accounting, it belongs to trade and industry. An accountant is a description of qualification. Professional accounting is a description in respect of the familiarity and knowledge with and ability with the profession, with the industry. So the prohibition of use of the term accounting therefore is not reasonable. If one passing off as a accountant, that is a criminal offense. Now, Mr. Leung prohibits 3 things: professional accounting, registered accounting, and certified accounting. Now, my analysis is if one claims to be registered, if one claims registered accounting, you don't refer to an accountant, but you refer to accounting. But you say registered accounting. Registered accounting is not a job, it's not an industry. You say you have registered. You registered with some organizations or an organization. So from where have you registered? If he has an overseas qualification, say in Canada, or from Mauritius. I'm sorry, for Mauritius. Mauritius is a country. Say if he is a registered accountant in Mauritius and he claims to be a registered accountant, then you can say you are a registered accountant of Mauritius. If he can't just put down registered accounting, then it's not misleading. But if there is no place in the world from where he has registered as an accountant and he claims to be a registered accountant, or he claims registered accounting, then he is misleading. not that you are a registered accountant in Hong Kong, but you are not a registered accountant anyway. That may be dealing with the point raised by Mr. Leung, because Mr. Leung is concerned whether one is misled into believing that a certain person is registered with the HKICPA. If certified, who give you the certification? You cannot say I certify myself. I think the problem is with the term professional. If you say you're professional, unless you say this professional or profession means the profession or professional quality authorized or recognized by a certain professional organization. So at least half of the term is descriptive. Well, I have been I've been working on accounting jobs for half a century, though I have not registered as an accountant or set for examination. I am in the profession. You may say you don't use the term professional accounting, but you can use professional bookkeeping. But some people are doing the work of more than just bookkeeping. Now, that's why I have a strong view against prohibiting the use of professional accounting and criminalizing the use of the term. I have strong doubts about it, but I'm not so strongly against registered accounting or certified accounting, because there must be somebody with which you have to obtain certification or registered with. Well, I just want to know whether we can bring the gap closer, and I put it out to you as I give it to you for some thoughts. As said in the case, that person used the term professional accounting. No, registered accounting. Oh, I've misread that. Mr. Chen Chen-ying. Thank you, Chairman. With regard to Mr. James To's concern, this is something we did discuss at length, and there were such concerns. But the problem is that the law that we are going to amend is the Professional Accounting Ordinance, Professional Accountant Ordinance. So, professional accountant, that is a definition, blah, blah, blah. If we say that professional accounting is a descriptive term, then shouldn't the ordinance be amended as well? Otherwise, you are not going to prohibit people using the term professional accounting in the body of the law, but you use the term in the professional accountant in the title of the ordinance. Will that be contradictory? Now, someone who has been working in the accounting profession for many years and he wants to use the term professional to describe his work, and you want to agree to that, but how can you deal with the if you permit that, then how can you allow the term to be used as a title? So should Mr. Leung consider this? And how are you going to deal with the title? And also in respect of A2 in the annex, and the police in taking enforcement action, if there is no evidence to show that it intends to mislead people to believing that people will reasonably believe that it's a registered practicing unit, then it will be very unlikely that the ICPA will refer the case to the police. Can you confirm, Mr. Leung's? Can you confirm this? We can tell other people that the association, and also Mr. Leung have confirmed that if there is no intention, then the association will not report or refer the case to the police. That is one way to put people's mind at ease.
ICPA, can you confirm or tell us the criteria for referral? Thank you. At our first meeting, a member raised a question about using the term 專業會計 professional accounting. However, it doesn't provide audit services. It only provides a bookkeeping service, and there is nothing in its publicity to mislead the public that it can carry out statutory audit work. And our reply was it was unlikely that we would refer the case to the police. That was true, but we were referring to professional accounting, where it's a bit different from the term registered accounting, because the advertisements hinted or claimed that it was registered with us. So there is nothing in the law to prohibit the use of registered accountant. So we didn't take any action. Can Mr. Chen follow up? You still have time. So registered accounting and certified accounting, I think we have the consensus that they should be prohibited. But for 專業會計 professional accounting, there should be further consideration. However, it echoes what's in the title of the bill, professional accountants. So I don't know whether the administration or Mr. Kenneth LEUNG can come up with a way out. ICPA, also on professional accounting, is quite at this point quite similar to that of Mr. James Teo. Well, is there any leeway here? The name of the bill is professional accountants. Starting from 1973, members of the ICPA are called professional accountants. So it's not really about professional accounting, but accountants. I'll have two questions arising from Mr. Chen's point, because I want to follow up at once. So you don't rule out you don't refer the complaints, but anyone can report to the police that there is no ruling out that a competitor may refer the case to the police causing nuisance. And secondly, I think you agree that using the term professional accounting is not as serious as using the description registered accountant or a certified accountant. I don't know whether the impression I got from your reply was accurate or not. Now, is it that if a person used the description registered accountant or authorized accountant or recognized accountant, the gravity would be higher? Ms. Alice Mack, of course, I understand Mr. James Teo and also views from another professional organization. I asked Mr. Kenneth Leung whether companies that are very experienced in providing bookkeeping services would be affected, and the answer from Mr. Leung was no. Now, although I'm worried that current members of the industry may be affected, but I have received many complaints involving financial intermediaries, the unscrupulous ones. Very often, they purport himself to be accountants. I've given a list of the names to Mr. Leung. 8 out of the 10 firms or people arrested have called themselves accountants, and many victims will just trust these unscrupulous intermediaries since they have the term 會計 accounting. Well, although the person doesn't call himself an accountant, members of the public would think that it is a practice unit. So we have to educate the public. Even with this amendment, I think some of the cases might not be tackled because in a complaint case, the firm called itself 專業會計 professional accounting, and then the person has disappeared. Probably it is not registered, and some of them call themselves account practice unit. So the amendment may not be able to tackle those unscrupulous companies. At least the public can be educated. They will understand that even though a person or company use the term accounting, that doesn't mean that he is to be trusted. At the meeting, I asked how we can allow the public to make a clearer distinction. Now, for a veterinary or a medical practitioner, he has to present his practicing certificate, and for real estate agents, they have their registration number on their name card. I think that is the best way to ensure that or to confirm whether somebody is registered. I know this is outside the scope of this bill, but can that be done, ICPA? We said that we would discuss that in the relevant committee within the Institute. We'll do so ASAP. Can you tell us the outcome of your consideration? I hope we can come to the decision within the first half of this year, because we have other things to attend to. Mr. James, so I've received similar cases as Ms. Alice Mack. I've done an analysis. I think the question doesn't lie with the prohibited terms because they are inclusion. They just ask somebody to do some verification. And as part of the scam, the victim, in fact, the money lender is inclusion with those, and for the borrower, he just wants some proof. So the bill cannot address those scams. Now, this is my analysis from the perspective of these crimes. And now I'd like to respond to the question raised by Mr. Chen Chenying. The Professional Accountants Ordinance, Professional Accountants, 專業會計師 in Chinese must be read together because it is a qualification. Professional accountant is a qualification. I think what we want to regulate is the act. And the description that can be used to mislead the victims. So whether it is registered or authorized, I think it is good to have Mr. Kenneth Leung's bill because we can ask the place of registration or the place of recognition or authorization. But as regards the term 專業會計, professional accounting, now, Mr. Leung, if this term is dropped from your list of prohibited items. Now, because even the ICPA used the word registered, well, you may have undercover operations to investigate. If after a long discussion, the individual claimed to have claimed to be a registered accountant, then it would be much easier for you to enforce the provisions. Once the individual used the term registered or recognized, then he can be caught. I think it would be better if you work on the word registered or recognized or chartered. All right, if there is no further response from Mr. Leung, or Mr. Leung wants to respond. Why have I chosen the term 專業會計 professional accounting as one of the prohibited terms? I didn't choose it arbitrarily. Well, we have been discussing this bill for more than 2 years. Accountant or 會計, this term cannot be monopolized by the profession. We have case laws in other jurisdictions. However, in our law here, there is a contradiction. We can use the term accountant. If you ask somebody and you ask him what is meant by accountant, he may say 會計 or 會計師. It's not like a doctor. The term doctor cannot be used by someone who is not a doctor. But we have not prohibited somebody from calling himself an accountant. There is no such prohibition in the law. Even though you have not studied to be an accountant, you can call yourself an accountant. And the name of the ordinance is Professional Accountants Ordinance. People will ask you whether you are a professional accountant. I think it is hard for the for members of the public to reconcile this contradiction. So is accounting referring to the work or the person? It is difficult to make a distinction. And the latest response from the Hong Kong Accounting Professional Association. Second point. Now, I have no intention to ban somebody for calling himself a senior accountant, and experienced accountant, public accountant, so on and so forth. So why can't somebody call himself an experienced accountant and senior accountant? Because there is nothing in the law to prohibit that. And they can call themselves a senior taxation practitioner, and still that can attract business. Why must I ban the term professional accounting? This is because of the translation itself. I think a further discussion cannot resolve the problem. If I were to introduce a bill called professional IT in the future, that would be a point to ponder as well. I think we have more or less exhausted all questions, right? Any more? Chairman. This is a private member's bill from Mr. Kenneth Leung. I'd like to ask Mr. Leung whether he has no intention to move any amendments. Because I don't know whether Mr. Leung would like to further consider our views. Now, if he isn't going to propose an amendment, that's fine, because we can then do our own CSA. So what is your position, Mr. Leung?
Well, I think the focus is the term 專業會計 or professional accounting. Well, I will not say that I will not think about it, because my mind is always thinking. You just speak into the microphone, you need to turn back. My brain is for thinking. I want to solve the problem, I want to deal with the question, and I don't want to make people feel that we are bullying some people, we are doing something unjust against a small group of people. I just want to listen to the advice of the clerk. If I just want to make a slight amendment, how much time do I have? If we can proceed with clause-by-clause study of the day today. There is no urgency on my part. He is the sponsor of the bill. Just like the government's bill. If they want to have more time, then we'll let them have more time. So he doesn't need to ask the question. We really hope that Mr. Leung will go back and think about it, and he needs time. Say, for example, 1 month. And after 1 month, then, yes, in fact, the ball is in Mr. Leung's court. Give me a month to think about it. Mr. Leung, we are not at the end of the session, and if this bill is to be put in the line, it will be just a difference of 1 or 2 weeks, and we can also consider whether we need to study, we need to have a meeting again or not. If we are able to complete clause-by-clause study of the bill, then we can have a pending meeting, whether we need a 4th meeting or not. You may have something you want to come back, and therefore we'll have the 4th meeting. But I think you should not try to avoid another meeting and then simply say that you're not going to think about it. We can study the bill clause by clause today, and then you can go back and think about it, Mr. Leung. Mr. To, I think he is to consider the term professional accounting. And if we are to embark on clause-by-clause study of the bill, then he may change the wording, and therefore you will have to you will have to study the clause again. And this bill is not too long, so can we have clause-by-clause later? Well, I want to know whether there is any room for moving the bill, and also whether there's any room for calling another meeting. I just don't want to cause further trouble to the HKICPA and the administration to come again for another meeting. Assuming that we don't care about any question, let us assume that we end the study of the bill, then the earliest is the 27th of March for second reading, resumption. And the earliest is the 27th of March, if is for second reading resumption. And there are a lot of dates, all the way to June and July. So it's up to you. Every week. We are not at the end of session. Now, if it is in the middle of March, it will be earlier. Then there is one meeting in April, and then afterwards it will be May because of the budget. Well, I don't need that much time. You want to think about it? Give me a week or so then. Can we have a meeting after 2 weeks? All right, let us arrange a meeting after 2 weeks. It will not be long. I don't know whether it will clash with the FC meetings. I still believe that there is a time slot available. We can have a meeting in March or April. Maybe in March, please. Will that clash with... I think the most important thing is not to clash with the FC, Finance Committee meetings. All right, we have one more meeting. Well, just like what Mr. Toh said, we will do clause by clause at that time. Yes, give me a week or so then, Chairman. What about the written reply? You give a written reply on how you are going to deal with the term professional accounting or 專業會計. Whether you have any new proposal or you stick to the gun. Can you give us a short paper on that? All right, I can do that. Well, then we can conclude our meeting today. So without further ado, we can end our meeting. Thank you.